उसको लेके आइए ना, इतना लंबा जजमेंट है। कौन डेटा कौन लिख रहा है? कहीं भी नहीं समझ आए तो लोग के पूछेंगे। आप ही हैं साथ में? कोई फैक्चुअल एरर हो तो हमको तुरंत टोकेंगे, ठीक है?
बीसी पे बीसी से भी ज्वाइन की है।
अच्छा ठीक है, तो दिख तो नहीं रहा है यहाँ
आ जाएंगे कल।
ठीक है।
एक जगह 92 की जगह में 82 हो गया है ऑर्डर में।
क्या चीज़?
92 लिखाना चाहिए, वहाँ 82 लिखा है।
जो अपलोडेड ऑर्डर है?
जी जी।
अच्छा हम एक सेकंड चेक करते हैं। दिखाई दे। कहाँ पे बताइए पेज नंबर? पेज नंबर बताइए।
पारा 6
लास्ट टाइम पेज नंबर 5 लास्ट टाइम ऑफ पेज
हाँ,
नंबर
18/12/92 होना था।
92।
Okay, just देखिए। The batch of appeals टोटल कितने अपील्स हैं टोटल? समीर जी
399 on behalf of the land users and one appeal from the
399
union.
totaling 400 first appeals have been filed against the have been filed under section 11 of the Requisition and Acquisition of Immovable Property Act 1952, within bracket, hereinafter referred to as the Act of 1952, against the arbitral award passed by learned arbitral tribunal, which has been numbered as arbitration case number 5 of 2013. Out of the 400 appeals, one appeal being FA number 367 of 2018 has been filed by Union of India, and the other appeals have been filed by the claimants.
लॉर्डशिप हम लोग की तरफ से 398 है फर्स्ट अपील।
टोटल 399
और एक इनका
एक दिन का
यूनियन ऑफ इंडिया
टोटल 399 है।
398
399
फाइल बाय द क्लेमेंट्स।
400 नहीं है,
398
टोटल 399
टोटल 399 है। उसमें से one is filed by Union of India, being FA number 367 of 2018. The Union of India has challenged the enhancement of the awarded amount so far as it relates to the rate of compensation with respect to the acquired land, and have also challenged the award of solatium at the rate of 20% and also interest, and also award of interest as awarded by the learned arbitrator. Their further grievances that the learned arbitrator had no jurisdiction to enter into and decide the compensation with respect to those persons who had taken the compensation from district land acquisition officer by putting their signature and without registering any protest. And the learned arbitrator ought to have confined the award with respect to those persons only who had not taken the compensation. Correct? So far as the claimants are concerned, they are seeking enhancement of the rate of compensation as awarded by the learned arbitrator by submitting that the materials placed on record have not been properly appreciated, and they are seeking, and with particular reference to exhibit, both Hana exhibit 4 and 12.
12.
With specific,
4 and 12, madam.
yes, with specific reference to exhibit 4 and 12. So far as the grant of compensation in connection with trees and houses standing on the property is concerned, no dispute has been raised. And accordingly, there is no argument in that connection. Correct? Thus, the dispute is in connection with rate of compensation, so far as the land is concerned, and enhancement of compensation with respect to all the claimants. Before proceeding further, it would be relevant to refer to the background in which the learned arbitrator was appointed. the background in which the learned arbitrator was appointed and as argued by the learned counsel for the parties is as follows. 1. The properties in the present case was requisitioned by the Union of India by the Defence of India way back in the year 1941, and the Defence of India remained in possession of the property. In the meantime, the aforesaid Act of 1952 was enforced. In terms of the provisions of the aforesaid Act of 1952, the land involved in the present case, which is relating to 4 villages, namely Sugnu, Sugnu, Garni, Garni, Lalganj, and Khatang, Khatanga, Khatanga, Katanga.
Gari है GARI.
GARI, GARI करेंगे, है ना? ये स्पेलिंग मिस्टेक है, हम लिखा रहे हैं इससे. This is Biren Mehto versus Union of India, decided on 16/1/2008 by High Court of Jharkhand. इसमें फैक्ट्स ठीक लिखा हुआ है, फैक्ट्स तो सही लिखा हुआ है. गाड़ी करेंगे हम.
एक और है लालगंज.
हाँ, लालगंज was acquired under section 7 of the aforesaid Act of 1952 on 30/5/1917. Thereafter, the compensation was assessed and was paid to a number of land losers by the Deputy Commissioner Ranchi. However, some of the land losers had approached the authority for appointment of arbitrator to determine the correct value of the land acquired, but no steps were taken, and ultimately those land losers of 4 villages filed a writ petition in the year 1991 for appointment of arbitrator. The High Court, by the order dated 12/9/91, 11/10/91, 31/10/91, and 11/10/91, directed the state government to appoint arbitrator under section 8(1)(b) of the aforesaid Act within 3 months, and to determine the quantum of compensation on the basis of market value relating to the land of land losers, which was followed by a notification dated 18/12/1992 issued by the state government appointing Shri R.C. Sinha, a retired judge of Patna High Court, as an arbitrator. Immediately thereafter, the Deputy Commissioner Ranchi noticed that the arbitrator was appointed in connection with only those persons who had approached the High Court. Consequently, the Deputy Commissioner requested the government to issue notification for inclusion of other 753 cases relating to all the land users, and to modify the notification dated 18/12/1992. Consequently, a notification dated 5/6/93 was issued, modifying the earlier notification dated 18/12/1992, including 753 cases of land users of the aforesaid 4 villages for determining the rate of land. Since the scope of arbitration was extended beyond those persons who had filed a petition, the fresh notification dated 5/6/93 was challenged by the central government before the High Court. Thereafter, the Deputy Commissioner again sent a letter dated 30/10/93 requesting for cancellation of the notification dated 5/6/1993, indicating that 5/6/93 notification referring all the 753 cases for arbitration may not be proper. Thereafter, on the basis of the letter dated 30/10/1993, the state government issued notification dated 18/11/1993 cancelling the notification dated 5/6/1993 and restoring the notification dated 18/12/1993. It was the subsequent notification dated 18/12/1993 which was challenged by altogether 20 petitioners. On their behalf and on behalf of 753 land users. And the said petition was subject matter of consideration before this court in the case of Virendra Mahato and others versus Union of India. Reported in 2008 within bracket 1 bracket close JCR 415 within bracket JHR. A copy of which has been placed on record by the Learned Counsel for the Union of India. And so far as the aforesaid factual background which has been taken from the aforesaid judgment is not in dispute by the Learned Counsel appearing on behalf of both the parties. The said petition filed by Virendra Mahato and others, Supra, was dismissed by this court, by a division bench of this court on 16/1/2008, citing numerous reasons for dismissal. and consequently this court refused to disturb the notification dated 18/11/1993, which had cancelled the earlier notification dated 5/6/1993. As a result of which, the arbitration would have remained confined only to those petitioners who had approached this court way back in the year 1991. The said judgment passed by this court dated 16/1/2008 in the case of Viren Meheto Supra was challenged before the Honorable Supreme Court in civil appeal number in SLP within bracket C bracket close number 20729 of 2008, in which leave was granted and it was numbered as civil appeal number 7152 of 2012. The Honorable Supreme Court observed in paragraph 1 in paragraph 4 of the the civil appeal number 7152 of 2012 was decided was allowed in terms of the order dated 25th of September 2012. The Honorable Supreme Court in paragraph 4 of the order passed by the Honorable Supreme Court, in paragraph 4 of its order, has observed as follows. पैराग्राफ 4 को कोट करेंगे, ठीक है। Ultimately, the Honorable Supreme Court was of the opinion that the High Court was not justified in rejecting a reasonable request made by the petitioners in writ petition number 2273 of 1995, and the Honorable Supreme Court also took note of the fact that the persons who have lost their lands because of requisitioning are poor, illiterate and scheduled tribe people, and in a matter of this nature, the good conscience should have prevailed on the respondents of the case, that is Union of India and others, to have accepted the reasonable request made by the claimants instead of arguing the matter on mere technicalities. The Honorable Supreme Court observed that the Honorable Supreme Court, ये पैरा 5 भी कोट करेंगे, कोट पैरा 5 also. The Honorable Supreme Court ultimately restored the notification issued by the state government dated 5/6/1993, and upon being informed that the arbitrator appointed under the state notification was no more. The state government was directed to appoint a new arbitrator, a retired judge, a retired High Court judge, to decide the lists between the parties and also in respect of those persons who have lost their land pursuant to the notification issued by the state government dated 5/6/1993 as expeditiously as possible. The Honorable Supreme Court also observed that the arbitrator should decide the steps should be taken as expeditiously as possible in view of the fact that requisition of the land was done by the central government way back in the year 1972. Para 7 भी quote करेंगे. The Honorable Supreme Court further clarified that they have not expressed any opinion on the merits or demerits of the case of the parties to the list.
पारा 5 नहीं पारा 6 होगा.
पैराग्राफ 5 तो ऊपर ऑब्जर्वेशन कोट किए हैं, ये पैरा 6 होगा ना.
पारा 6
हाँ, पैरा 6 and 6, 7, 8 ये तीनों को कोट करना है.
ये पारा 4
हाँ, पैरा 4, 5, 2, 8.
6 7 8.
पैरा 5 भी कोट किए.
अच्छा ठीक है.
Pursuant to the judgment passed by the Honorable Supreme Court, the learned arbitrator was appointed to decide the lists between the parties. It was the specific case of the claimant as recorded by the learned arbitrator under Chapter 2 in a summary manner that the compensation was paid, that the land was, which is quoted, एक पन्ना है, इसको कोट कर देते हैं, 2 पन्ना, ठीक है. ये इंटरनल पेज 7 and 8 को कोट करेंगे. As many as 14 documents were exhibited, which are as follows on behalf of the claimants. Chapter 3 में है ये.
Chapter 2.
हाँ, Chapter 2 में तो claim है.
जी.
Chapter 3 में list of documents है.
List of documents.
Before the learned arbitrator, the claimants adduced altogether evidence of 4 witnesses. So far as the Union of India is concerned, the summary of the case has been recorded in Chapter 4 of the award. Which is as follows. The Union of India had filed as many as 13 documents, which are as follows. Chapter 5 में. On behalf of Union of India, premises were examined, whose details are as follows. Roman 14, 15 and 16 में है, internal page 12 में. The learned arbitrator framed the following issues for consideration. ABCD chapter 6 में है. The learned arbitrator took up issue number A and B together and while deciding the same, the learned arbitrator has specifically quoted paragraph 6, 7 and 8 of the order passed by the Honorable Supreme Court, and was of the view that the objection filed by the Union of India with respect to deciding the case of all land users as mentioned in notification dated 5/6/1993 and not confining to just 20 writ petitioners. Such objection was not maintainable and not tenable. The learned arbitrator ultimately recorded that the claims were maintainable and the arbitral proceeding is not confined to 20 writ petitioners, but it covers all the land users mentioned in the notification dated 5/6/1993. By deciding issue number C, the learned arbitrator has proceeded to consider whether the awards made by the authorities is correct and observed that under section 8(3) of the Act of 1952, the compensation payable for acquisition of any property should be the price which the requisitioned property would have fetched in the open market if it had remained in the same condition as it was at the time of requisitioning and being sold on the date of acquisition. The learned arbitrator observed that, in other words, the market value of the property on the date of acquisition is payable. The learned arbitrator referred to the report of District Land Acquisition Officer, within bracket, hereinafter referred to as DNAO, bracket close, which was marked Exhibit 10 and prepared a summary with respect to all the 4 villages which were involved in the case and recorded that the District Land Acquisition Officer for all the 4 villages, 3 का दिख रहा है, चौथा का एक तो ये है internal page 16 for Khatanga,
पेज 18 में है मैडम।
17 for गाड़ी का अलग से
17 पेज
गाड़ी का कोई चार्ट नहीं है। पेज 16 का है
इसमें एक ही रेट दिया है, सब क्लास का।
नहीं गाड़ी का
गाड़ी का पेज 17
पेज 17
इसमें से
गाड़ी में चार्ट नहीं दिया है।
चार्ट नहीं दिया, एक ही रेट दिया है, फ्लैट रेट चार्ट, ऑल क्लास ऑफ फ्लैट।
नहीं गाड़ी का कहाँ लिखा है इसमें?
ये एक मिनट सर,
गाड़ी का नहीं है, गाड़ी का चार्ट नहीं है।
चार्ट नहीं है मैडम सर, एग्जिबिट 10 में देखा जाएगा।
अच्छा,
उसमें फ्लैट रेट दिया गया फॉर ऑल क्लास ऑफ फ्लैट।
एट फ्लैट रेट रुपीज 5882 पर एकड़।
रूडॉट से
5882
इसमें डिटेल डिस्कस किया गया लॉर्डशिप के
ये
जेटी
गाड़ी का एकदम फ्लैट रेट दिया है 582 पर एकड़,
जी लॉर्डशिप।
ठीक है, लेकिन बाकी सबका धान कैटेगरी वाइज दिया है, राइट?
जी लॉर्डशिप 7 कैटेगरी सेम दिया गया।
नहीं गाड़ी का अलग रेट दिया है।
जी लॉर्डशिप उसमें पाया गया कि ये
गाड़ी का 5882 पर
ये
एकड़।
एग्रीकल्चर लैंड नहीं है, इसलिए इसको एक ही रेट दे रहे हैं।
और रेट भी अलग है 582 फ्लैट रेट, लेकिन इसमें अलग अलग कैटेगरीज का रेट है।
जी लॉर्डशिप
The learned arbitrator, with respect to the village Lalganj, Khatanga and Sugna, has awarded, sorry,
सुगनु
Sugnu
ये
has,
18 का रोमन 2 में क्लियर लिखा हुआ है कि क्यों दिया गया फ्लैट रेट
ठीक,
बाय द डीएलओ।
ठीक, has awarded compensation at the same rate with respect to different categories of land. Those were Dhan 1, Dhan 2, Dhan 3, Dhan 1, Dhan 2, Dhan 3 and Parti Rayati. So far as village Gadi is concerned, the learned arbitrator has observed that, the DLO had observed that all lands were to be treated as single class of land and flat rate of rupees 5882 per acre was fixed.
ये 18 का रोमन 2 में लॉर्डशिप क्यों दिया गया वो
ठीक है,
DLO
I will just take care of it. The discussion of the report of DLO at Exhibit 10 as done by the learned arbitrator with respect to each of the 4 villages is as under. सारे विलेज का है, अलग अलग है, सब डालेंगे। The learned arbitrator thereafter, from paragraph 10 onwards of the award, recorded his findings and was of the view that Exhibit 10 would be irrelevant Exhibit 10 was irrelevant as it was contradictory and arbitrary considerations were applied in fixing the compensation amount for the land of the 4 villages. The learned arbitrator also observed that the various classes of land were sold at various prices, and the rationale given by the concerned officials was in not considering the sale deeds of highest consideration was unjustified. It was also observed with respect to Exhibit 10 itself, in paragraph 11 of the award, that the concerned officials simply ignored the sale deeds by giving passing remarks that the lands were far off from the lands under acquisition. The arbitrator was of the view that the acquisition of nearly 2,000 acres of land, 36 chains cannot be considered to be too big a distance, more so when the transfer of land in the vicinity was quite scarce, and possibly this was so on account of requisition by the Defense Department, and only a few sale deeds were available. While further discussing Exhibit 10, the learned arbitrator recorded that in paragraph 12 that the lands were requisitioned as early as in the year 1942-43, and since then they were under the possession of military for about 30 years and were developed due to establishment of cantonment, and was of the view that under such circumstances the classification of land into various types was redundant. The learned arbitrator was also of the view that the four villages were contiguous to each other and were similar in potentiality. But on the one hand, flat rate of rupees 582 per acre was fixed for village Gari, on the ground that it was not agricultural land. And on the other hand, the other three villages, Lalganj, Sugnu and Khatanga, was done by classifying the agricultural land. The learned arbitrator ultimately was also of the view that so far as village Gari is concerned, some of the land sale deeds of the year 1970 and 71 were not considered on the ground that there was big variance in the sale price. But one of them, that is sale deed dated 2/4/1971, was made the basis for fixing the flat rate of rupees 582 per acres. In the aforesaid, after the aforesaid discussion in connection with Exhibit 10, right from paragraph 10 to 12 of the award, the learned arbitrator was of the view that there was no justifiable basis for fixing compensation, and the authorities have not assessed and paid the proper market value of the land acquired under the Act of 1952. The arbitrator was of the further view that flat rate of the land should have been taken for determining the compensation amount, and then referred to Exhibit 5 that the Honorable High Court had also affirmed the flat rate of rupees 2,000 per decimal for land of village of some other village acquired for military purpose. And ultimately, the issue number C was decided by the learned arbitrator against the Union of India by holding that the awarded amount was not proper and was not as per the market value. Thereafter, the learned arbitrator went on to decide the issue number D and referred to the issue number D and observed that the claimant had claimed a flat rate of rupees 2 lakhs per acre of land and rupees 1 lakh per house and rupees 10,000 per bed and rupees 500 per tree, apart from solatium at the rate of 30% and interest at the rate of 9% to 15% per year. And such claim was totally denied by the Union of India. The learned arbitrator considered numerous judgments which were cited and also observed that the claimants had examined 4 witnesses of the 4 villages and all the witnesses had deposed on identical lines. And had claimed rupees 2 lakhs per acres in the year 1971 due to their location and potentiality of development. The semi-town area near to Ranchi town and that the town was and the acquired land was near National Highway number 33 and State Highway number 32. The arbitrator was of the view that the witnesses had stood the test of cross-examination. The Union of India the learned arbitrator thereafter considered the evidence led by Union of India and discussed the same in paragraph 19 of the judgment. With respect to the witnesses, witness number 1 on behalf of Union of India, the learned arbitrator observed that the witness number 1 and witness number 2 had deposed on identical lines, but they had not visited the villages between 1942 to 1970, and they were recently posted. And witness number 2 had admitted that National Highway number 33 runs between Ranchi and near to the 4 villages in Kashmir. The learned arbitrator also discussed the evidence of the district land acquisition officer. Who referred to the government rates of land which were fixed on 1/1/2013. And he had also stated that the villages appear to be developed as they are near Ranchi town, but could not say anything about the position of the land at the time of acquisition. He also admitted that he had not visited the village during the period between 1942 to 1970. The learned arbitrator thereafter refused to consider the DT 27/7/1978 relied on behalf of the Union of India by stating that it was of a different village altogether. In paragraph 23, the learned arbitrator has referred to the various documents which were exhibited on behalf of the claimants. Which were regarded as not relied upon by the learned arbitral tribunal. The learned arbitral tribunal had rejected Exhibit 4 as well as Exhibit 12, which has been heavily relied upon by the Counsel for the Appeal on behalf of the claimants during the course of arguments before this court. The learned arbitrator thereafter in paragraph 24 found the documents which were relevant for ascertaining the market value. Those documents have been enlisted in paragraph number 24 of the award. Those are Exhibit 1, which is the survey map, and also Exhibit 5, which was the certified copy of the judgment of the High Court dated 9/3/98, within brackets Savicherva, Lakra and others dash MA number 38, 39 and 132 of 1994 within bracket R. And observe that the High Court, while hearing the matters, affirmed the award of the learned arbitrator, wherein flat rate of rupees 2,000 per acre was granted for the lands acquired for military purpose, along with solution of 30% with interest at the rate of 12% per year, and recorded that the land in the present proceedings were similarly situated. The Exhibit 5 was relating to the acquisition of the year 1986-87, that is about 15 years after the acquisition involved in the present case. And ultimately, the learned arbitrator, while considering Exhibit 5, adopted in order to arrive at the approximate market value of the year 1971, adopted the reverse process and deducted the market value by 10% every year, right from 1986 to 1971, and arrived at rate of rupees 42,000 in the year 1971. It would be per acre. Per acre, है ना? Per acre. The learned arbitrator thereafter considered Exhibit 7, which was a certified copy of the sale deed of the year 1963 pertaining to village garden for an area of 5 kathas, and it was rupees 24,000 per acre. And in order to arrive at the market value in the year 1971, the learned arbitrator enhanced the learned arbitrator added 10% every year up to 1971, right from 1963, and arrived at rupees 51,446. And thereafter deducted 20,000 towards development cost, and on the basis of Exhibit 7 was of the view that the market value on the date of acquisition of the present land would come to rupees 41,000 per decimal. Per acre. The learned arbitrator considered the Exhibit 8, which was the original sale deed relating to the village Lalganj, dated 13/11/1962, and observed that as per the sale deed, the rate was rupees 30,000 per acre. The learned arbitrator adopted the same method as was adopted in Exhibit 7 and added 10% every year with respect to the rate right from 1962 to 1971, and arrived at rupees 70,726 per acre, and deducted 20% towards development cost, and as per Exhibit 8 arrived at the market value to approximately rupees 57,000 per acre. The learned arbitrator also considered Exhibit 7, which was the certified copy of the sale deed of village Gari dated 2/4/1971, which was for 23 acres 11 chata and 27 square feet, which was sold at the rate of rupees 27,000 per acre. The arbitrator also observed that the sale deed was one of the village involved in the acquisition and was near about the date of acquisition and could be used for the purposes of determining the market value. The learned arbitrator thereafter noted that the acquisition was of the year 1941, the acquisition was of the year 1971-72, and the properties remain in possession of the Defense Department for more than 30 years, and the same was developed due to the establishment of cantonment area. The arbitrator also observed that it was not in dispute that the properties were situated very near to the capital city of Ranchi, within bracket the then town of Ranchi, bracket close, and that it was not in dispute that the national highway and state highway is adjacent, and water bodies in form of rivers were also present in the vicinity. The learned arbitrator ultimately took the average of the valuation arrived at by referring to Exhibit 5, 7, 8 and 9, and calculated the average of 4 valuations, which came to rupees 41,750 per acre, and was of the view that the same would be the just and reasonable market price at the time of acquisition. The learned arbitrator was The learned arbitrator fixed this rate as flat rate for all types of land. The learned arbitrator also observed that in Exhibit 10, the district land acquisition officer himself had recommended flat rate for village Gari, which was contiguous to other three villages, and also referred to Exhibit 5, wherein the High Court had also granted, which was a High Court judgment whereby the flat rate granted by the arbitrator was approved. The learned arbitrator held that there was no justification for categorization of land for assessment/payment of compensation. Thus, the learned arbitrator rejected Exhibit 4 as well as Exhibit 12 as relied upon by the claimant, and relied upon Exhibit 5, 7, 8 and 9 for assessment of compensation. Exhibit 5 was used by deducting 10% per year to arrive at the valuation as on in the 1971. Exhibit 7 and 8 were used by increasing the value 10% every year from 1963/1962 onwards till 1971 to arrive at the valuation of the year 1971. And Exhibit 9 relating to village Gari was also considered, which was in connection with one of the villages which was acquired in the present case and was also found to be in the vicinity with respect to the time regarding acquisition of the land. The learned arbitrator thereafter by paragraph 27 onwards considered the claim regarding solatium and interest and referred to the various judgments as relied upon by the parties. They were reported in follows 1, 2, 3, 4, 5. 1993 supplementary within bracket 2 SLC 149 Union of India versus Hari Krishna Costa. Number 2 1998 within bracket 2 LAL क्या हो 188 Sanicherwa Lakra versus Charo Ora within bracket Exhibit 5. Roman 3 bracket 2010 bracket close 14 SCC 357 within bracket Dilawar Singh versus Union of India, and Exhibit 11 order dated 11/2/85 passed by Honorable Supreme Court in SLP civil number 12723 and 12747 of 1984 Harban Singh and others versus Union of India. the learned arbitrator rejected the plea of the learned arbitrator also considered that the question of entering into an agreement in Form K arises when the offer is accepted. And since the agreement in Form K was not entered into, there was no justification for payment of only 80% of likely compensation. To this, the learned counsel for the appellant has specifically submitted that it was not 80% of the likely compensation which was paid, but 80% of the persons had accepted the compensation, and the compensation was accepted in full, whatever was offered to them. And for this, the learned counsel for the appellant, Union of India, has referred to exhibit number. वो exhibit number कौन सा था इनका? आपका exhibit number कौन था? जैसे signature जिसमें था सर?
Yes.
To the records received from the land acquisition.
R2D1, R2A1,
R2
A1. जैसे हम लोग का 4 सेट में R2, उसके बाद A1, A2, A3, D1, B2, B3, C1, C2, C3, तो तीनों का C1 में, A1 में या B1 में, C1 में.
आप exhibit number बताएंगे हमको.
R2A1.
R2A1, which has also been perused by the learned counsel appearing on behalf of the claimants. आपने भी perusal किया है? The learned arbitrator ultimately held that in absence of any agreement in Form K, there was dispute right from very beginning in connection with compensation amount, and it was the duty of the Union of the authorities to get the matter referred to arbitration in terms of Section 8 within bracket 1 within bracket B of RAIT Act, but they did nothing. And on account of this, there was a delay in appointing arbitrator, and therefore the solution cannot be denied to the claimants. However, the learned arbitrator was of the opinion that 20% solution would be just and reasonable. The learned arbitrator thereafter took up the point of interest and was of the view that as the compensation was paid up to the year 1975, it would be just and reasonable that at least from 1/7/1996, simple interest at the rate of 9% per annum be granted. so far as the manner of payment is concerned, the learned counsel for the learned arbitrator was of the view that the number of claimants under Section 628 awards is very large, and the payment is to be made only on persons entitled on proper inquiry and verification. And it was not possible and practical for the tribunal to make individual awards under such case. The award was given award-wise and was concerned with the persons entitled to receive the awarded amount under 628 awards, which were in question, a list of which was made part of the award as Appendix 1, and such persons were called claimants/land users. The learned arbitrator ultimately awarded the compensation in the following manner. Award जो है ना लास्ट में ये चार्ट बना हुआ है इसमें पेज 35, ठीक है. After having passed the learned arbitrator thereafter directed for payment to the claimants of the awarded amount by 31/1/2015, failing which the claimants/land users would also be entitled to simple interest at the rate of 15% per annum on amount G. Amount under column G till from the date of the award till the date of payment. The quantum G, the amount under column G included the compensation as per market value on the date of acquisition at the rate of ₹41,750 per acre, and then the amount already paid was deducted. And on the remaining amount, solatium of ₹20% of solatium at the rate of 20% was calculated. And interest at the rate of 9% per annum was calculated from 1/1/1976 to 31/7/2014, and on the entire sum, the future interest at the rate of ₹15% per annum was calculated, was to be paid as a default clause if the amount is not paid by 31/1/2015. Consequently, interest at the rate of 15% by way of default clause was payable not only on the balance principal amount but also on the solatium of 20% of the balance amount, and also on account of interest at the rate of 9% per annum. This is the entire summary of the award. I can't hear you.
Yes, Lord.
This is the entire summary of the award.
Default payment will on the awarded amount.
Yes, yes. Default payment on the awarded amount.
For the award always inclusive of.
उसके बाद इनका सॉफ्ट कॉपी आया है सबमिशंस का, वो सबमिशंस पूरा एज इट इज रहने देंगे. आपका भी रिवाइज्ड आया है, आपका भी किसका रिवाइज आया याद नहीं है, लेकिन सारा सबमिशंस आपका 4 पन्ना का है. आई वांट टू रिटेन इट. उसको थोड़ा सा पैराग्राफिंग हम कर देंगे, ठीक है? हो गया?
मेरे
Now
साइड से
the-
रिवाइज आया,
जी
मैं रिवाइज फाइल किया।
हाँ, हमको याद नहीं किसी एक की तरफ से रिवाइज, जो मैंने पुराना डिस्कार्ड कर दिया है, इसी का कर दिया मैंने. और आपने अपना जो जो जजमेंट्स आपने प्लेस किया था वो पैराग्राफ वगैरह लिखा ही हुआ है उसमें. After hearing the learned counsel for the parties, the point for determination in the present case would be as under. Now this is important, please take care whatever I am dictating on this. कहाँ गया वो?
इसमें एक ऑर्डर और आया डॉक्टर सबसे एडिशनल सप्लीमेंट अवार्ड बना है इसमें।
अच्छा हाँ,
उसको भी देखना
रुक जाइए. सप्लीमेंट्री अवार्ड में कुछ विशेष तो है नहीं, बट
628 के जगह पे 623 केसेस पाया गया है
ओके.
और उसमें कैलकुलेशन भी किया गया है
Just-
कि कितना सबका इंडिविजुअल बनाया गया है।
A supplementary award has also been prepared by the learned arbitrator. Wherein the पढ़िए जरा कहाँ है वो?
That is page number 55.
No, I've got that, लेकिन उसमें कहाँ है रिड्यूस किया है? Okay. Wherein certain mistakes were rectified by the learned arbitrator as follows. ये पैरा नंबर 39 है, इसका पेज नंबर 235 से. Consequently, the award was confined to land users up to 623 awards. 623 awards only. And through the appendix, through appendix 2, appendix 1 है this appendix 1 तो इसमें है ही नहीं. Through appendix 2, the award was made as per substitution petitions which were filed and allowed before the learned arbitrator. And appendix 2 was directed to form a part of the award dated 1/8/2014. It was also observed that appendix 2 is to be made after the payment as per appendix 2 is to be made after proper verification and inquiry of the substitution petitions. And the calculation was also required to be checked. And if any person slash legal here interested in any award raises any claim slash objection, the respondent number 2, who is respondent number 2 in the award?
DL Ranchi.
The District Land Acquisition Officer Ranchi was to decide the same by speaking order after giving opportunity of hearing to the parties.
Deputy Commissioner Ranchi.
The Deputy Commissioner. ये तो डिस्ट्रिक्ट लैंड एक्विजिशन ऑफिसर लिखा है रिस्पॉन्ड नंबर 2. डिस्ट्रिक्ट डिप्टी कमिश्नर को थोड़ी दिया है. अब पेज नंबर 46 में देखिए. The district land acquisition officer Ranchi and the revenue कर्मचारी DLO Ranchi. Internal page 2 of the award.
So far as party position is concerned, my lord.
Yes, you see internal page 2 of the award. Deputy Commissioner was not even appearing before the learned arbitrator. है ना? District Land Acquisition Officer Ranchi.
The state of Jharkhand through deputy commissioner.
कहाँ पर आपके अवार्ड में? अरे वो छोड़िए ना, आप नेक्स्ट पेज में आइए ना.
Page number 2, not 6.
पेज नंबर 2 डिस्ट्रिक्ट लैंड एक्विजिशन. अब डीसी बैठ के क्या करेंगे?
Yes.
इट इज नॉट पॉसिबल. अब ऐसा काम करिए कि पैसा मिल जाए. ऐसा मत बताइए कि बस रिट पिटीशन फाइल होना शुरू हो गया कि डीसी इज नॉट एक्टिंग एज पर द.
Yes, this was creating fair price.
नेक्स्ट पेज में है द डिस्ट्रिक्ट लैंड एक्विजिशन.
District land acquisition officer and revenue कर्मचारी.
In the present proceedings also, a number of substitution petitions have been allowed, but the same would certainly be observation भी हम लोग दिए हैं, है ना उसमें? It is only for the purposes of the first appeal and nothing more. The same would certainly be subject to the methods which has been adopted by the learned arbitrator. ठीक है? अब हम लोग point for determination में भी आते हैं. वो कहाँ चला गया? ये क्या है? Yes. The points for determination by this court would be as under. 1. Whether the arbitral proceedings was required to be confined only to 20 writ petitioners or to all the land users as mentioned in notification dated 5/6/1993. B. Whether the amount of compensation awarded by the learned arbitral tribunal by the award dated 1/8/2014 read with supplementary award dated 18/9/2014 is requires any interference. बस इतना ही. हाँ. Third, whether the learned arbitrator was justified in awarding interest and solatium in awarding interest and solatium in the matter arising out of acquisition of land under the Act of 1950. So, but whether the learned arbitrator was justified in awarding future interest at the rate of 15% per annum that too by including the interest component as awarded from 1975 till the date of the award, and thereby awarding interest on interest. और कोई बच्चा? इतना ही है?
My lord, I'm sorry, my lord.
Yes.
Interest slash default interest.
हाँ, interest slash default interest. Interest slash default interest.
All 653 are on same footing now.
Sorry?
All 653, 20 have come, and the list was enhanced to 653. That was also one of the issues that
That I've already said, whether it is to be confined to 20 repetitioners or it will be for all the land users as mentioned in notification dated 569.
the list of 20 that people get from the auto, that will be one issue. CM sir.
The list of 20.
This writ will be valid. That was cancelled. The 4 writ petition included 20 that was cancelled. Then this 20 reads that it should be for all.
Okay.
That is Para 3 will be 20. Para 2.
Para 2 we have already said.
No, only for clarity I am giving that these are the 20 persons who actually protested and he was in the first one.
The list of 20 persons who were party in CWJC number 2273 of 1994 at Patna, which was decided on 10/1/2008, has been referred to by the Learned Counsel appearing for Union of India by producing a certified copy of the said judgment. ये पहले जितेंद्र है कि धर्मेंद्र है कि क्या है? वीरेंद्र मैं which is as follows. ये लिस्ट इसमें से ले लेंगे. देखिए हम आपको कहाँ से लिखा है अवार्ड से लिखा है वो पटना से का जो जजमेंट हुआ था उससे एक इन्होंने ये दिया है, इसको मैं मार्क कर रही हूँ इससे, राइट, इससे लिस्ट सीधा टाइप कर लेना, ठीक है, और इनका रिटन सबमिशन से फाइल हुआ वो डालना है और आपको सारा पॉइंट फॉर डिटर्मिनेशन आपको दे देना है, ठीक है। अब इसको जो है इसको टाइप होने दीजिए, ठीक है, और इस ऑर्डर को भी हम अपलोड कर देंगे, गिव मी सम टाइम, और आई कैन स्ट्रेट अवे डिक्टेट इट टुमारो, कल डिक्टेशन देते हैं फिर आपके सामने लिखा है, कोई बात नहीं, आपके थे ही नहीं, आपको
So you have actually your leadership has taken all the issues.
I have taken all the issues. I will कल नहीं हो पाएगा, कल दिक्कत है, परसों, ठीक है, post this case for further dictation. Yeah. court time is over.
Yes, yes, I know.
अभी हम लोग का दूसरा board orders.
Yes, I know.
My lord, one thing,
Yes.
my lord,
Anything
permit.
missing, you just let me know.
My lord has stated that it was perused, that my lord, R2.
It was.
Exhibit.
R2 was also perused by the respondent when appellant asked.
हाँ, that you have not perused.
Perused but not accepted content.
Yes,
That day I-
perused. You see, it shows receipt of the awarded amount.
Whatever it shows, my lord, we have not accepted that. Here I have made a statement,
Okay.
perused. But then
Okay.
because
ये
you
जगह
are
लिखे
given
हैं
in the
the
argument
counsel
stage,
for
that
the,
much time
just a moment, the counsel for the claimant had perused the R2 number कितना था आपका?
R2 A3, R2 B1, R2 B2.
ये लिख के देंगे प्लीज,
हाँ, लिख के दे सकते
आप लिख के दे दीजिए है ना?
तुरंत।
But at the same time, they did not accept that only they did not accept that the entire awarded amount as quantified by district land acquisition officer DLO क्या है इसका नाम?
District Land Acquisition.
District Land Acquisition Officer was paid to the claimants. इनका कहना ये है 80% ही पेमेंट हुआ था, आपका कहना है कि 80% लोगों को पेमेंट हुआ।
हाँ।
दोनों में फर्क है।
दोनों में आसमान
फर्क है ना?
बट ये कोई डॉक्यूमेंट नहीं लाए, यदि ये सबमिशन है तो मेरा एक लाइन टू
वो
डिस्प्ले दिस
बस हो गया, बस इतना ही है ना, बाकी जो
जी।
That's all?
Day after
Yeah.
Right, my lord.
At 2:50. Day after tomorrow at 2:50.
tomorrow.
Very, very all right.
आप लोग का जो कोटेशन पार्ट है एक जना करिए, डिक्टेशन पार्ट एक जना करिए, और हो सके तो कल तक हमको प्रोवाइड करिए। ये वो डिक्टेशन वाला जो एक्ट है ना, वो चाहिए कॉपीज के साथ ले रहा है।
From day list for order B to pay item 7, second appeal 185 of 2019.
आप
On behalf of all the respondents, we have received वकालतनामा by yesterday. We have filed it.
सेकेंड अपील में आप अपील हो जा रहे हैं, इसके लिए आपको अवार्ड मिलना चाहिए। आप बताइए कहाँ है आपका क्वेश्चन ऑफ लॉ?
इसमें 2 आई है, इधर 2 आई नोट पेंडिंग।
अब कौन सा आई पेंडिंग?
ये डिफेक्ट नोट करने के लिए उसमें एप्लाइड नंबर
तो ये डिफेक्ट भूल गए, और बताइए क्या क्या डिफेक्ट, कि क्या आई है फाइल?
ये 2159 डेज का डिले है, और दूसरा है कि एप्लाइड नंबर 1 जो है डेट की उसका लीगल या रिकॉर्ड करेक्शन।
पहले तो आपका सब्स्टिट्यूशन अलाउ करते हैं, आपको ऑब्जेक्शन है?
No.
आपके कौन है सीनियर?
I'm Chanchal Jain, advocate Chanchal Jain.
कहाँ है वो?
I'm based out of the station for some medical reasons.
पहले आपका सब्स्टिट्यूशन अलाउ कर देते हैं,
11720।
ये तो इग्नोरिंग डिफेक्ट। ये क्या डिफेक्ट था जो आप ये फाइल में है?
इसमें वो मुसलमान लक्ष्मी थी,
Not aiding मौसमात लक्ष्मी देवी as a party in the appeal. क्यों नहीं इनको बनाया पार्टी?
इसका लीगल यस ऑलरेडी
One son, appeal number 1, and 6 daughters. Okay, they are already on record, correct? चलिए, देखिए आइए नंबर 1172 of 25, this petition has been filed for ignoring the defect of not adding Mausamat Lakshmi Devi as party in the present second appeal. The learned counsel for the appellant has submitted that Lakshmi Devi had expired on 17/10/2018, who is the mother of the appellant number 1 and has also left behind 6 daughters who are appellant number 4 to 9 in the present case. He submits that the legal heirs and successors of Lakshmi Devi are already on record. Her name may be, and accordingly the defect be. The learned counsel for the respondents, नाम बताइए अपना.
Ma'am, Abhishek.
Abhishek Kumar has no objection so far as the prayer for ignoring the defect is concerned. Considering the submissions, IA number 1172/2025, seeking ignoring the defect, the forced defect is hereby allowed. और बताइए, और किसका डेथ हो गया?
ये नंबर 11721
111721. ये क्या चीज है? ये तो लिमिटेशन पिटिशन.
इसी में नोटिस
ये तो डिले हुआ ना. आप बताइए किसका डेथ हो गया बोल रहे हैं?
वो हो गया. हाँ.
ठीक. अब इसका क्या करें? 159 डेज. क्या ग्राउंड बनाए हैं आप? आप एक चीज ऊपर लिखिएगा. द मिस्टर सो एंड सो submits that he has received wakalatnama on behalf of all the respondents and undertakes to file the wakalatnama by day after tomorrow.
Ma'am, we have filed it by today.
Okay, he has already filed wakalatnama. Office is directed to place it on record. बताइए इसमें डिले में क्या बोलना है आपको? 159 डेज. बताइए कौन सा पैराग्राफ?
7, 8.
Okay, due to death of Lakshmi Devi. Any objection to continuation of delay? Yes, counsel. IA number 1172/2025. This petition has been filed for continuation of delay of 159 days in filing the second appeal. The learned counsel for the appellant has referred to paragraph 6 to 10 of the interlocutory application, seeking condonation of delay. The learned counsel for the respondents has no objection so far as the prayer for condonation of delay is concerned. After hearing the counsel for the parties, the petition seeking condonation of delay and being satisfied with the cause shown, the petition seeking condonation of delay is hereby allowed. अब बताइए क्या करना है? Next. ये किस हेडिंग में चल रहा है? ओ अभी आप 2019 का आपका डिफेक्ट रिमूव हुआ. अब क्या करना है बताइए, इससे पहले कि दूसरा कोई मर जाए. बताइए. हाँ, आपके सीनियर कौन है? बताइए बताइए कब करिएगा? शुभ दिन शुभ समय बताइए. क्या है मैटर भाई? आपको मना किया आपके सीनियर ने कि फाइल खोलना नहीं है. हाँ तो जरा बताइए क्या है आपका? आप कौन है? प्लेंटिफ हैं? कौन? Who are you? Lost in all the courts, right? क्या सूट फाइल किए थे? 87 का सूट. हाँ, स्पेसिफिक परफॉर्मेंस. बस बस अब इसका कुछ नहीं है. बताइए क्या बनना? कब करिएगा?
कोई डेट
कल करते हैं सुबह सुबह.
कल.
कोई डेट मतलब कल?
परसों.
परसों तो हम नहीं जानते, हम रहेंगे कि नहीं रहेंगे, कल ठीक है, कल आप करेंगे ना?
हाँ।
With the consent of the council for the parties, close this case tomorrow. Under appropriate heading. इसका heading सही करा लेंगे.
This can be taken on Thursday or Friday if it can be completed.
चलिए आपका तो लॉटरी निकल गई, 2 दिन से जल्दी मिल गया.
My senior is not here.
तो आप तो सुनेंगे ना, कॉन्करेंट फाइंडिंग है, स्पेसिफिक परफॉर्मेंस का केस है, आप कितना ही सीनियर को सुनना है.
Let me have some directions.
चलिए थर्सडे को करते हैं. थर्सडे को 10:30 बजे at 10:30 as per case.
Orders item 8, second appeal 178 of 2009.
बताइए.
What is the service report with respect to responder 14D1 to 3 has not been received.
किसका सर्विस रिपोर्ट, रेस्पॉन्ड नंबर
14D1 to D3. They are the legal representative of defendant responder number 14.
और भी तो हैं उनका रिसीव नहीं हुआ है.
नहीं, और एक 12E का है that has been received by his nephew.
Received by nephew.
And so far the respondent 14 is concerned.
14
E
yes.
signed by some other person.
14
E.
E. तो किसको कौन कौन अनसर्व्ड हैं?
Answer में है आपको 14D1 to D3 and
14D1 D3 and
14E.
14E करेक्ट. और 12E को हम लोग एक्सेप्ट कर रहे हैं, रिसीव बाय nephew.
By the nephew. Regarding my lord the service of notice upon 14D1 to D3, it may be kept pending for awaiting service report.
कहाँ के हैं ये?
ये है चतरा जिला के.
एड्रेस सबका सेम है ना?
एड्रेस सेम.
OTE का भी सेम एड्रेस है, करेक्ट? सबका सेम एड्रेस है. आपका एड्रेस भी सेम है क्या? पार्टीशन सूट है क्या?
टाइटल सूट से आई हुआ है. एड्रेस सेम है, प्लेंटिफ एंड डिपेंडेंट का एड्रेस सेम है.
पुलिस स्टेशन से भेजते हैं बस. ऐसे नंबर 178 of 2009. Council for the appellant is directed to take first step for service of notice upon respondent number 14D within bracket 1 to 14D within bracket 3 and 14 within bracket E through the concerned police station, for which requisites be filed within a period of 1 week. अब कौन बचा? 12E.
12.
So far as the counsel for the appellant has submitted that as per the service report of respondent number 12E, it has been received by his nephew. He submits that the notice be accepted as validly served. आपको कोई objection? The learned counsel for the appealing respondents has no objection to the prayer made. Accordingly, notice upon respondent number 12 in bracket E is accepted as validly served. इसका क्वेश्चन ऑफ लॉ कहाँ है?
It was admitted on 8/11/2012.
8/11/2000.
This is the first appellate court committed error of drawing instance from the evidence
चलिए देखिए, आप इसको करिए, पोज दिस केस ऑन 22 दिसंबर अवेटी सर्विस रिपोर्ट। उस दिन सर्विस रिपोर्ट आ जाएगा तो बस फिर आप लोग तैयारी करिए,
ठीक है।
ठीक है?
22nd भी समझ
उसके बाद पोस्ट वेकेशन किसी डेट में फिक्स कर देंगे।
हाँ।
सर्विस कंप्लीट हो जाएगा तो पोस्ट वेकेशन फिक्स कर देंगे।
Item-
2009 का सेकेंड अपील है ना, 20 साल से ऊपर हो गया? नहीं हुआ, अभी तो बहुत नया है, न्यूली बॉर्न सेकेंड अपील।
Item 9, second appeal 189 of 2010 along with item 10.
हाँ बताइए।
Sir, responding number 10 has died. To 2 this time. And similar matters, serial number 10 and also. Yes, notice has been issued.
एक सेकेंड, इसमें रेस्पोंडेंट नंबर
10 died.
10 हैज एक्सपायर्ड।
Yes, yes.
दूसरे में भी होंगे ना रेस्पोंड नंबर 10 पार्टी,
हाँ.
तो उसमें भी बताइए ना। रेस्पोंड नंबर 10 का क्या नाम है?
Sahira.
साहिदा खातून। कब मरी हैं? ऐसा नहीं सिर हिलाइए, इतना पुराना सेकेंड अपील में आपको डेट तो बताना पड़ेगा ना, कब मरी?
सर्विस नोटिस मुझे फाइल पता चला, पता कंफर्म कर लेते हैं, उसमें तो भी कंप्लाइन करेंगे।
आपका पहले ही 7/10/25 को
Yes.
आपका ऑलरेडी ऑर्डर हो चुका है दैट रेस्पॉन्ड नंबर 10 हैज एक्सपायर्ड, राइट? तो बस अपडेट होने में टाइम नहीं लगेगा। और दूसरे रिकॉर्ड में शाहिदा खातून कौन है रेस्पॉन्ड नंबर?
उसमें बस सिर्फ लगा कि नोटिस
रेस्पोंडेंट नंबर, नाम तो दोनों में ही मरी होंगी ना, कि एक ही केस के लिए मरी? शाहिदा खातून मस्ट बी पार्टी। सिविल डिवीजन है क्या साथ में? शाहिदा बीबी, वाइफ ऑफ मोहम्मद लतीफ। Saida Khatun is not a party. Division में she is not a party. ये रिविजन किस लिए फाइल हुआ?
ये ऑर्डर 47 अगेंस्ट सीपी।
एडिशनल एविडेंस को लेकर किस लिए रिविजन फाइल हुआ?
I am not appearing. I am appearing in the appeal. Most probably, what came from my learned friends. Section 47 में objection बिल खारिज होता है।
सेक्शन 47 में क्या ऑब्जेक्शन फाइल किया?
Execution.
एग्जीक्यूशन में।
पता नहीं, I am not. Appearing उसमें नहीं है, दूसरे उसमें।
Decree is not executable for improper
That is under
description of
section
it.
47.
That's right.
So that was rejected, and then they have preferred this revision. Parties may be the same.
उस
Maybe
पार्टीज तो
num-
सेम होना चाहिए।
Number can vary.
हाँ, पार्टीज तो सेम होना चाहिए, ऐसा कैसे है?
Serial number may vary, but the parties are to be, should be the same.
The trial court judgment in the connected case is arising out of the suit or it is arising in the execution case?
Should,
It is arising out of the suit.
in the second appeal.
Yes, in the second appeal.
Yes, it should. Arising out of suit, affirmed in appeal.
ओके टाइटल सूट 88 का टाइटल सूट
0.
चलिए इसमें तो साहिदा खातून पार्टी नहीं है, शाहिदा बीबी है इसमें
Yes, civil division.
सिविल डिवीजन में. हाउ शी इज नॉट अ पार्टी इन दिस केस?
जिसमें वो शायदा खातून आ
आ रहा है
समाज शायदा खातून
यहाँ से, ये सिविल डिवीजन का.
Yes.
हाँ ये है तो रिस्पॉन्ड नंबर 1.
Number may vary, but
शाहिदा खातून इन सिविल डिवीजन नंबर 26 और 2010 शाहिदा खातून. शाहिदा नाम नहीं है, स्पेलिंग है SAYDA खातून.
Both are different. That is, she is wife of Ali Hassan and she is widow of late MD Nafi. Saira Khatun was party.
ठीक है इसमें मत लिखिएगा. कितना आपको कितना हफ्ता आपको टाइम चाहिए?
2 weeks.
7/10 को पहली बार हुआ है ना? ठीक है, जब तक ये अपडेट नहीं करेगा उसके बाद ही का डेट दे.
2 weeks में कर केवल 10 का केवल करना है.
टाइम ही कहाँ है आपके पास? बिजी.
रिस्पॉन्ड नंबर 10 निकला. ठीक है.
तो वो 7/10 को मरी है ना, 7 जनवरी के बाद रख देते हैं. तब तक तो अपडेट कर जाएगा, तब तो हम एकदम सीधा प्रोसीड कर जाएंगे, फिर हम कुछ नहीं
एडमिटेड सेकंड.
तो नहीं प्रोसीड करना चाहिए.
नहीं. और एक सेकंड वाला में सिर्फ नोटिस आएगा, फ्रेश नोटिस आएगा और 12 सीक और 12 डी प्रेजेंट इन करेक्ट
सिविल डिवीजन में. नॉट ट्रेस्ड, तो अब किसको फ्रेश हम नोटिस करें?
12 सी एंड 12
इन सिविल डिवीजन नंबर 26 of 2010, notice upon respond number 12C and 12D has been received. The undelivered notice of 12C and 12D has been received with a report not traced. Counsel for the appellant. The earlier also notices were issued and it remained unserved. Substituted by counsel for the appellant. Prays for time to take appropriate steps. Either to take fresh steps for service of notice upon 12C and 12D at their present and correct address through speed post, or to file an appropriate petition seeking substituted service of notice within 2 weeks, failing which the civil division as against respond number 12C and 12D shall stand dismissed without further reference to the bench. Post on second appeal में तो आपको substitution फाइल करना है,
उसमें
दोनों साथ में. उसमें भी नोटिस करना है.
substitution का रिस्पॉन्ड 10.
Post on 22nd December.
दोनों में सेम पर्सन है, सेकंड रिस्पॉन्ड वन है.
नहीं इसमें वाइफ का नाम अलग है, हस्बैंड का नाम
सेम है.
सेम है. नहीं साइदा खातून
लेट
लिखा है.
मोहम्मद नफे, वाइफ ऑफ लेट मोहम्मद नफे.
लेट मोहम्मद नफे. ठीक है, दूसरा में
लेट एमडी नफे.
हाँ
इसमें वन
वो मोहम्मद, ये मौसमा साइदा खातून अलग है, एक शाहिदा खातून अलग है. रिस्पॉन्ड नंबर 10.
वो अलग है।
इसमें लिखिएगा शाहिदा खातून, SAHIDA खातून, वाइफ ऑफ अली हुसैन। सेम नाम से दो आदमी हैं, अलग अलग स्पेलिंग। चलिए सीरियल नंबर क्या है इसमें, क्या किया?
First rotation was of 187 days. The next rotation case is going also, it was very day tomorrow, day after tomorrow, as also this is.
अभी करते हैं ना, टुमारो डे आफ्टर क्या है? आपका नोटिस नहीं गया है?
Rotation में क्या कर दिया?
कौन कर गया है?
I'm appearing for respondent number 2 in serial number. And for the bank.
देखिए 4:30 बजे के बाद किसी के एब्सेंस में ऑर्डर नहीं कर सकते। एग्जीक्यूशन का क्या स्टेज है?
Exercise will not we have filed objection, objection paper, objection file करना।
अभी ऑब्जेक्शन डिस्पोजल होने में टाइम लगेगा। एप्रोप्रिएट ऑर्डर होगा जिस केस से।
Next.
हाँ नेक्स्ट डे तो ऑटोमेटिक आएगा नेक्स्ट, बिना डेट के कोई केस थोड़ी आता है। ठीक है?
Orders are not being taken up, your lordship.
किसी एक बात मुझे बताइए,
नहीं, हम
ऑर्डर्स
समझ-
करके क्या
नहीं वो
करेंगे?
नहीं, कुछ ऑर्डर्स जिसमें अर्जेंसी हो उसी हम
नहीं आप हमको सिर्फ इतना बताइए, जब लिटिगेंट मर गया,
हाँ, वो
न
सब है,
लिटिगेंट को
वो-
होश है, न
वो-
वकील साहब को होश
हम-
है,
we-
तो वो डेड केसेस का हम क्या करें? उससे
we are-
अच्छा वो केसेस करें
I'm not
जिसमें
justifying
पार्टीज
it.
आर देयर और उसको हम डिसाइड करें। आई एम मोर इंटरेस्टेड इन डिसाइडिंग दोस केसेस इवन इफ दे आर ओल्ड केसेस, वो कोई बात नहीं। लेकिन सब्स्टिट्यूशन, थर्ड जनरेशन सब्स्टिट्यूशन चल रहा है तो उसका हम क्या करें?
वो तो
मतलब इट्स वेरी हार्श, लेकिन
नहीं
उसमें हम अपना समय क्यों बर्बाद करें?
नहीं एक हम I just point there are cases where we have filed additional for framing additional questions.
तो ऐसे जो भी केसेस हैं, आप जो है सुबह 10:30 बजे उसका नंबर अगर आप दे देंगे तो 4 बजे हम पहले वही केसेस कर देंगे,
ठीक
लेकिन अदर साइड को खबर कर देंगे।
हाँ खबर करके तो और जिसमें इंजंक्शन भी फाइल किए हैं
इंजंक्शन
At least नहीं वो
कहाँ,
कैसे-
यहाँ कुछ हो नहीं
महीना,
रहा है तो
दो
सिविल
महीने-
कोर्ट में क्या हो रहा है? कुछ नहीं हो
महीना
रहा
2
है।
महीना बाद ही सुना जाए, हम नहीं बोल रहे हैं
नहीं
लेकिन
ऐसा नहीं है, लेकिन सुबह जो भी आपका मैटर रहे
ठीक
तो अगर आप दे देंगे तो वैसे
ठीक।
तो एडवांस लिस्ट आता है ना,
ठीक
एक सेकेंड, वैसे एडवांस लिस्ट आता है, ठीक है? अगर आप एक दिन पहले भी दे देंगे ना तो नोटिस में हम लोग बोल देंगे कि 4 बजे पहले ये आइटम टेकअप,
ठीक
जिससे कि दे आर आल्सो पुट टू नोटिस दैट दीस मैटर्स हैव टू बी टेकन अप फर्स्ट। लिस्ट तो सभी लोग देखते हैं,
एकदम
ठीक है?
वही एक छोटा सा सीरियल नंबर 24 में फर्स्ट अपील एडमिशन के लिए
बाकी रेडी है?
नेक्स्ट हाँ रेडी
नेक्स्ट डे क्यों करें?
एडमिशन
रेडी है एडमिशन के लिए?
एडमिशन में
और भी है फर्स्ट अपील?
एक
कौन क्या चीज है?
ये मेरा 7-11 में प्लान रिजेक्ट हुआ था, उसी का फर्स्ट अपील
एडमिट कर दीजिए। Just a moment. FA number 191 of 2025. The admit call for records from the concerned court. Issue notice to the respondents. ये दिगंबर जैन समाज, ये वही है क्या? तो वहाँ पर वो कोडरमा वही का प्रॉपर्टी है जिसमें यहाँ महीनों केस चला था, वही है क्या? आपको नहीं पता, आप लोग नहीं थे ना उस समय यहाँ पर। एनीवेज, इशू नोटिस टू द रेस्पोंडेंट्स अंडर स्पीड पोस्ट as well as ordinary process for which recusals be filed within a period of 15 days from today. January 15th के आसपास का कोई डेट नहीं। ऑफिस टू ट्रैक स्पीड पोस्ट। आपका क्या?
Relationship serial 23 is listed under heading for orders. Only for the reason that respondents' notice has been issued by them, and they have also received it by way of SAR. It can be posted under the heading for admission because all the notices have been served with it. You can go rather now and also be filed for the rest of the
appearance is complete?
Appearance is complete for the rest of the respondents. Only for respondent 6 it has not been done, which is
Yeah.
only, which has been received. The notice has been received by his son.
FA number 123 or 25?
Yes.
Is it the partition suit?
It is for it was the declaration of right title.
Sorry?
It was for the declaration of right title.
Okay. Counsel for the appellant has submitted that notice upon respondent number 6 has been served, has been received by his son. He submits that. The notice be accepted as valid. Considering the submissions, the notice upon respondent number 6 is accepted as valid. Respondent number 1 to 5 and 7 have already appeared by filing wakalatnama. The service is complete.
So far 6 has not been appeared yet, Lord.
कोई बात नहीं, सर्विस इज कंप्लीट. सर्विस कंप्लीट हो गया, उनको मन हो आए नहीं मन नहीं, अब बेटा को नोटिस मिल गया, अब उनके घर नहीं जा सकते हम लोग. 1 to 7, 1 to 5 and 7. You are appearing for 7 also?
No, 1 to 5 only.
7.
Mr. Amit Sinha is appearing.
Anyways, whosoever is appearing.
They have already filed wakalatnama.
Office is directed to place this case under appropriate heading on next Tuesday. आपको क्या लगता है वो डिले कॉन्डोनेशन में बहस नहीं करेंगे, अभी पूरा बहस करेंगे? वो आपको पता है, इसीलिए हम जैसे उनका नाम सुन के ऑर्डर करना. आपको पता है, विल अपोज कॉन्डोनेशन ऑफ डिले आल्सो. पिछली बार भी हमको याद है, यू वर अपोजिंग, राइट? हाँ, थोड़ा सा जब देखिए आपका नाम तो हमको याद आ गया कि केस में आप अपोज कर रहे हैं, तो ऐसे सुन के करेंगे ना, ऐसे नहीं, मैकेनिकली तो नहीं करेंगे.
29 it may be posted on 14th of December also.
कौन सा? आपके हिसाब से डेट नहीं है.
Also 2nd of December I am not available also. I am going out of some personal difficulty also. It may be posted on 14th also.
ठीक है, 14th.